And earlier Supreme Court has observed something regarding that. Now let's have a look for the case, and I will just read the ruling which has been claimed in the said petition. This is a writ petition filed by one Guddu Wala from
That Bihar matter was withdrawn.
Bihar matter was withdrawn. In this matter, the reference of Bihar was also made.
Like who's in this Guddu Singh
This
matter?
Guddu Singh's matter, that Guddu Singh's really filed this. I'll just read Guddu Singh's relief.
This is a chance for it.
Yeah, the judge, please have a look what is the relief he has claimed. I'll just read one, I'm getting the copy or a hard copy of that. The relief one which he has claimed is that in the aforesaid facts and circumstances of the case, it is therefore most respectfully prayed that this honorable court may kindly to please to issue a writ order or direction in the nature of mandate inter alia directing respondent number 1 and respondent number 2 to pass necessary order for cancellation of the appointment made by various states in classes 1 to 5 on the basis of the notification dated 28/6/2018 bearing number so and so published by the respondent number 2 NCT, which notification has been passed by this honorable court in appeal number 5068 of 2023 and other connected matters, Devesh Sharma and other versus State of Rajasthan. So this relief that these appointments made pursuant to the notification of the NCT may be passed. That direction is sought in that matter. Yesterday the matter was approved. The reference of the Bihar matter, I also have the video one. That in that case you should go and review in the Devesh Sharma's case. As far as this case is concerned, where this matter is now under consideration, that has been adjourned for 4 weeks.
This is for what?
But the candidate is from duty, but he has sought cancellation for appointment of all the
No, but he's seeking execution of Devesh.
What he is saying is,
Just a minute.
so what he is saying that since Devesh Sharma's case, NCT notification has been passed, and now it has been held that the candidates having B.ed are not eligible for appointment as a primary tutor. Therefore, in the interim period, after notification of the NCT and till the date of Devesh Sharma's case, whichever appointment has been made in the entire area, those appointments may be passed. This is the prayer made in that.
In effect, it is they are seeking execution of Devesh.
So now the issue here which they have raised is also similar. They say on the basis of that law declared by the
How does this subsequent development affect the hearing of this case?
because they are also seeking the same way. They are saying that because of Devesh Sharma's case, the NCT's notification has gone, and therefore the appointment which has been made in the state of Madhya Pradesh, they may also be. This is their way. That is the basic way. So the matter now says the Supreme Court is seek of the matter. Could be appropriate this matter is adjourned for 4 weeks.
Now the Supreme Court will article that you fight in a state of dispute.
Secondly, now
How will it impact state of MP?
no, but when it comes in the
Notification was challenged in the state of MP. You took a plea that a matter in Devesh Sharma subjected you to the Honorable Supreme Court. There this Honorable Supreme Court that will wait for the Supreme Court judgment. Supreme Court says that you are ineligible. We have put an application that now you cannot continue with your eligibility situation. The interpretation is already gone.
same situation is already cannot make it legally covered and Mr. Gupta said. This is a matter which cannot be decided without a reply from the state government. It's a case where the reply from the state government has to be done. The state is yet to find reply. It's not that simple as my friend is saying that Supreme Court has passed the order in the case of Devesh Sharma. There are 70 cases. It would be right. The Supreme Court in the judgment of Devesh Sharma itself has said that the state could not have ignored the NCT notification as long as it was an therefore, now the question of that is
Copy from the High Court of Bihar.
what submission is this one that this matter?
They have provided a copy of the comparison of High Court of Bihar.
Yesterday it had been bench instead of Rupi, then Bihar yesterday it was mentioned before the court. That Bihar case court has said like this. They said no, you go in a review before Devesh Sharma. If you feel like that. As far as this matter is concerned, so my suggestion is
Devesh Sharma got reviewed. It's a law plan.
so Manoj said to Manoj, it will be against
There was no problem from the state of Bihar. It provided the copy. What was it? It provided this combination.
and the Bihar state Manoj makes we see that the court had again left it to the state of Bihar as far as that order is concerned.
Yes, why was this Guddu Singh filed?
Guddu Singh is filed, Manoj, that they are now because they say that after the declaration of law by the Supreme Court, state government
This must be filed by the government.
yes, the government. Yes. He said that all these appointments should be. Now they
I have fresh petition.
It was not even required because the reason being, Supreme Court has only declared the law. Supreme Court has not said as to what will happen to the cases of the appointment which have already been made. That is the issue before that this issue has to be examined. Because the Supreme Court in paragraph 34 of D.ed Sharma itself has said that the state of Rajasthan could not have ignored the NCTE notification. What had happened, the state of Rajasthan did not invite. The state of Rajasthan also did not invite the application, did not accept the application of the candidates who were having B.ed. Supreme Court said that was illegal. Once the NCTE notification was in existence, as long as it was not declared illegal, the state of Rajasthan was bound to not follow that NCTE notification. And that is the issue exactly here also. NCTE notification was declared illegal by the High Court of Rajasthan on 25.
How does this, the pendency of this case before Supreme Court, how does this hold us back from proceeding?
In the state of UP, well, this is the matter for the state of UP.
And here the petition is by
It is
candidates.
The petition is filed by the candidates who are D.ed, who are having D.ed.
Yeah.
Yes. Similarly, when a verified candidate, Guddu is a candidate who is having D.ed. Guddu said that before the law was declared by the Supreme Court, the state of UP has made about 60,000 appointments of the teachers, in which the candidates having B.ed degree have also been appointed.
So more or less, it's asking for sympathy.
No, it's not.
To save our services, save the services of B.ed.
No, it's not. It's not
basically that.
But it's not simple. It's a law. Law, because any law, it will be.
So probably you all were showing us some order subsequent to the election.
Yes,
So that indicates that they wanted these people out. The B.ed.
Supreme Court has stated yesterday. Supreme Court had said yesterday in that hearing matter.
Now the best course would be that they have to be out. They have to amount of service, and then thing has to be worked out. If some B.ed degree holder also holds a diploma, then of course he's entitled to be adjusted, but not otherwise.
Others will have to see the provisions of the RTA. Others will also have to see the earlier.
No, that the Supreme Court has seen already.
No,
why should we go into all that?
Supreme Court has said that NCT should not have issued this notification declaring the B.ed candidates as eligible to apply for. This is what the Supreme Court says, and therefore the NCT regulation has been declared to be NCT notification has been declared to be illegal. The question before the Supreme Court is, this issue of appointments already made was not an issue before the Supreme Court. Supreme Court has left it to the states. Even in the order of Bihar also, they have said we leave it to the state of Bihar. Now the issue what followers have to examine.
We got to the state of Bihar.
One of the issue regarding the appointment which have already been made. Because the question, one of please see paragraph the order,
The fate of those appointments.
one please have a look on paragraph 34 of the elections. Paragraph 34 Supreme Court says that the NCT notification held the candidates having their degree as eligible. In the state of Rajasthan, despite that notification being in existence on the date of advertisement, the candidates having B.ed degree were not held eligible. They were held ineligible, despite the NCT notification in place. Supreme Court said in paragraph 34 that the Rajasthan High Court has rightly held that until the notification issued by the NCT was declared illegal, it was not within the domain of the state of Rajasthan not to permit the candidate of B.ed in participating in the process of selection. Because on that day, the notification was very much in existence. Supreme Court said that once the notification was in place, one of the candidates having B.ed degree also has been permitted to participate in the exam.
Given the question on the following bench, in the roster. The other list. So then, of course, the adjustments will take place between benches. you want, then we'll hear it. Pass it over.
In my mind, for one is not that it's such which is going to have very wide ramification consequences of my lord. Now the down of the state government is very important. So I think that is the reason why I'm not over the chamber. And second, it was
Statement of senior counsel, I am also there, Lordship were also there, it was heard. They were replying, then court master advised that it was an ad hoc bench. Then the matter was split over. But
not my condition. There is a visa earlier that 5,000 vacancies. But 22,000 have been 2,000 vacancies are vacant. Why? Because we have not found, the government has not found eligible candidates, meaning thereby that we have not stressed on the rights not of the D.ed candidates. Still, thousands of vacancies are vacant. So this is an academic exercise in which the my learned friends, petitioners, counsel, strives are indulging.
they are already appointed also.
Most of them are already appointed. Even if not appointed, not this honorable board would be seized of the matter if some right is transferred.
See,
It is not a PIA.
petitioners here are diploma holders.
They are already
They are,
appointed.
all the petitioners, Lord, they are diploma D.ed holders.
They are already appointed.
So it's not like
They are already petition. On the other petitions, none of the petitioners have been appointed. This is there. If they can show up, this is why
There should be no dispute on this kind of a fact.
it should be very, very clear.
My learned friends, in one of the petitions, all of them have been appointed.
In one of the petitions,
Chalo, we have to only some only two things. And many now my analysis is, I can tell you, if anyone's life is transgressed, or anyone has been brought down because B.ed candidates are not competent, all this that. My contention in my return is that out of 25,000, only 22,000 appointments have been made. 2,000 appointments are vacant because these D.ed candidates could not qualify. So their right is not violated. Our participation, my lord, in the selection process has not in any way prejudiced or brought the competition. This is wrong. The competition is still there because they have not even qualified. And
Mr. Rora, we have this decided.
only one more thing, Lord, we are not shying away from arguing, but we don't want that contradictory orders should be passed into litigation. My learned friend has given us the.
Please argue the matter so that we can finish it.
But what the submission is, we are ready to order. There's no difficulty now. His submission is, will it not be appropriate to have a reply from the state government? It's the state government which has to give out as to how many posts were advertised, how many appointments
They have not filed any reply.
they have not filed. How many posts are still vacant? Whether they are prejudice because of our continuance in services.
What is the state doing since the last 1 year?
They will not follow because it was their rule, they have given appointment, they want them to continue because that would create a problem for them if someone is intentionally demonstrating they are sitting over it, they will not find it there.
How can you say that they will not file it? If the court says,
Mr. Bajpayee, in 1 year, state has not come out with any response. Why so? So this is under which department? School education, public instructions. Then what?
they have to say, they let the state government also file it.
You will have to, in fact, disclose a lot many things that whether there is any B.ed appointee who also holds a diploma, whether there is B.ed appointees who do not hold this diploma, charge has to be made. Then can their appointment be axed because of their judgment or not? Whether they can be adjusted or not?
They are not in view of the RTE, whether the B.ed
So
candidate.
that has been decided. That question has been decided by the Supreme
No,
Court.
the Supreme Court has said.
That the notification is bad in law.
The Supreme candidates having B.ed, but there is a provision in the RTA. The candidates who are having B.ed, they can be made qualified by undergoing that process. But now, that is not a step down. It's not a step down.
Actually, see the courses are totally different. The diploma course and the graduation course in education, and they are different. Different subjects are being taught, different type of education. Teaching is like.
It's not.
This is only for primary education.
Section
Primary school.
Primary teachers. Our section 22 of the RT. When the RT Act came into existence, at that time also the B.ed candidates were not eligible.
No, we are ready to hear. Please argue the matter. But states replies a little. No, Mr. Council, don't you think states replies
This
necessary?
will not be required by the reason one.
Why not?
Now let me answer this.
Yes, let him.
Go to reason one. At the NCT notification being binding on the state of Madhya Pradesh, they came up with their book only to bring it in consonance with the NCT notice. Now the NCT notification was quashed by the Rajasthan High Court with 30 primary article. Two, the Honorable Supreme Court by upholding the judgment of the Rajasthan High Court also declared it void.
What did the Rajasthan High Court say about
Said the
the?
NCT notification is
No, that is understood. What did they say about the appointees?
in the state of Rajasthan, my lord, the Honorable High Court granted stay on the appointments. At the initial stage itself, that they will not be given appointment because the High Court was aware of the fact that under the primary education, only D.ed persons are having that ability to teach that training can be given to them to go and take over studies of a child.
So there, this problem was not there.
It is not there. They correct that the Rajasthan High Court, Rajasthan Council, Rajasthan High Court are in much better aware. I am telling that.
Where is that judgment of the?
Our studies based in the compilation.
It is wrong that Rajasthan High Court had granted this state. In the state of Rajasthan, the candidates having B.ed were not permitted to participate. See, they were not permitted by the state issue.
Just that means, Mr. Gill, that no person with B.ed degree was appointed there in Rajasthan. So did not have, High Court did not have to deal with this kind of a situation.
Absolutely. What has happened is there were two petitions filed. One was with the B.ed candidates.
What about the other states?
In other states, that went from Bihar, when the appointments were made, there in Balakrishna
Of B.ed.
B.ed candidates, there the Honorable Supreme Court says that all steps taken subsequent to this notification stands invalid. That matters what has happened is, in High Court of Bihar, the matter was filed that look, there is a judgment of the Supreme Court. There was also one interim order in the Chhattisgarh matter, which judgment would be binding. The High Court of Bihar said that the Supreme Court judgment is binding. These candidates cannot continue in service. It was specifically clarified. Against that, the state of Bihar as well as B.ed candidates were impressive. And there was the one SLP was listed before Justice Bopanna's bench. There they said that it should go before the bench of Justice Anudha Bose, delivered at D.ed Sharma's judgment. The matter went before the bench of Justice Anudha Bose. Thereafter, arguing it for half an hour, ultimately the petitions were withdrawn. I have based both the matters on record that the High Court of Bihar has taken up this view that the D.ed Sharma as well as the Balakrishna judgment, they are binding, Balakrishna judgment, they are binding in nature. Subsequent thereto, all steps taken, government steps is validated. They have moved before the Supreme Court, withdraw the SLP, who? The state of Bihar as well as the B.ed candidates. Now, whereas one from state of UP come up, there may be from state of Manipur, one can come from the state of MP, one can come from state of Chhattisgarh. They have not issued this court under view when the notification has been declared invalidated. The appointments were made subject to outcome of the D.ed Sharma's SLP. One of the applicants is D.ed Sharma himself before this honorable court. In both SLP, the judgment was upheld and notification was filed. Now, whether they want to continue or not, let it not be the BSPC candidates, let it not be the B.ed candidates. The notification was first keeping in mind the right of those children who are now being allowed to be taught by these ineligible candidates without having that training. Because Article 21A is working day by day. Today also a person who is ineligible to teach is taking up a class. Who is representing that child before the honorable court? We will not go into service, they will not continue in service, but the fact remains that the notification was quashed because it was taking away the right under Article 21A, that is right to quality education. a right to be taught by a person who is very well trained. Now, if the single day continuance of them is infringing their rights,
But I think
Where is that judgment of the Bihar High Court?
provided a compilation. Please see,
So they were dealing with a situation where B.ed appointees were there.
yes. And can we see, what was taken up before the division bench?
What was the finally? What
They said that the judgment of the Supreme Court, D.ed Sharma and Bhagwan Krishna, they are binding. We have to go by that. So meaning hereby that the B.ed candidates were to make room for other C.ed candidates.
What did they say about those appointees?
That-
Patna High Court. Patna High Court is subsequent to Ganesh.
Yes. High Court is subsequent to Bhagwan Krishna also. It's a free judgment, Malad, if I can read this.
Where is that?
I provided,
The compilation.
no, it's a separate set. It's provided today itself. Which is with the Dipankar Gaurav's order. The first part is Dipankar Gaurav.
Pankaj Gaurav, yes.
Yes, now this is where the D.ed candidates, D.ed candidates withdrew their SFP. The second order is the Bihar High Court order, 22nd of September. Now, Maharaj, can we see what the Bihar High Court has dealt with? The respondent state has filed the above application. Where is it, Maharaj? It's a lot of order. The second order is set 22nd of September for the division bench.
Yes, sir. Oh, please read it.
ये देवेश दीपांकर गौरव टॉप वाले दीपांकर गौरव
It's also.
Actually, cut it, Mark. I can provide myself.
Have you given 2 copies?
Yes, I've given 2 copies. Now I've given this
You
copy.
should copy the need.
Eight. Gaurav. I put it. Here it is. Here it is. Right, I've given another step. Now, Dipankar Gaurav is the order number to make the D.ed candidates withdraw their SFP. After arguing for a while, learned counsel for the petition submitted that the client would not like to process with this petition. The petition supporting the expense was withdrawn along with pending applications. Now, this was withdrawn against this order. That is the next page. The respondent status filed.
Patna High Court, sorry.
Yes, ma'am.
This is 22/9. Yes.
The response status filed the above application seeking to clearly allege uncertainty prevailing by reason of the 3 orders of the Honorable Supreme Court annexed to the interlocutory. Annexure R by 1 the judgment of the Honorable Supreme Court invests the judgment of the Rajasthan High Court, setting aside the notification dated 2018 issued by the NCTE to include B.ed as an eligible qualification for primary school teachers was upheld. It was categorically held that B.ed cannot be qualification for the purpose of selection of primary school teachers to teach students 15 class 1. Annexure R2 was passed in a case where the very same notification was challenged, which was held to have been quashed by the judgment at Annexure R1. The consequential advertisement and subsequent steps taken in pursuance thereof could invalidate it. It was specifically noted that the state of Bihar was not a party in the above petition, but the pre-judged bench specifically recorded that it is expected that the state of Bihar will take into account the judgment at Annexure R1. Annexure R2 is a special petition where the interim order issued by the High Court of Chhattisgarh, which state the recruitment process came to be challenged. The division bench of the Honorable Supreme Court set aside the interim order and clarified that the recruitment process would be subject to the result of the consideration of the writ petition, which can only be in consonance with Annexure R1. We do not think that there is a lack of clarity in so far as the binding nature of the judgments of the Honorable Supreme Court at R1, R2, and that there is no apparent conflict in the order at Annexure R3. We find the petition to be misconceived, the interlocutory application stands rejected. So, Annexure R2 is that order which says that the advertisement on all steps taken thereto is put invalidated. Now, there, my lords, against this, the state of Bihar went into SLP, that is at the next page. It was listed before Justice A.S. Lopanna's bench, which passed the interlocutory order in Chhattisgarh High Court. There, my lords, it was withdrawn. Then senior counsel for petitioner seeks leave to withdraw the petition, permission was granted, the special leave petition was withdrawn. Then, my lords, the B.ed candidate went before the bench of Justice Anuruddha Bose, who delivered the judgment of D.ed Sharma. They are also after arguing for a while on this 31st of August, October, they have reviewed the SLP. In all merits, it is very much clear that any appointment of the B.ed candidates based upon the notification of 28 June 2018 in anywhere in the state of in this country, in any state, that is invalidated. They cannot continue for a day more. What to the same amount of their labor following this mandate?
Alright, so we'll proceed to the other case.
Only one thing, Lord.
Yes.
But that doesn't mean
Please cite all your judgments which you are during your arguments. We heard his arguments, we will hear your argument. We'll pass it over. Pass it over.
At the outset, first my learning objection of his notice, because he has not, in his long argument which he did just now, he has not disputed that all his petitioners, my lord, have failed to qualify in the test.
So, a statement.
So, Lord, that is my categorical submission that 2,000 was not still vacant. And, Lord,
We can always build that.
and what my learned is arguing on behalf of the children. This is not PIL. It is a petition vindicating the rights of those people who probably claim to be displaced because of the B.ed candidates. No, you cannot argue for the children. This is not PIL. First, you tell where is your locus. If we are in our appointment.
Alright, Mr. Rupai, a diploma holder has been subjected to selection and found to be unfit and not appointed. Then that's the end of the matter for that candidate. That's the end of the matter. So we'll observe that.
No, that has to be ascertained. That has to be.
No, we'll leave it to the recruiting agency. Why should we undergo all that exercise?
Not enter into an academic question, my lord. At the instance of a person who has no locus, my lord, may not be required to enter.
Which,
Why? Because when you have failed to qualify in the written test, how you can challenge? See,
Another time they say we are failed. What you said, are we appointed or are we failed?
No, they have one. They have
have you pointed out?
Because I'm not appointed, it's not for the
Mr. Counsel, Mr. Counsel,
my instructions are to
please.
They have failed to qualify.
What is your name? What is your name? Why are you arguing with the other counsel? Whatever you want to say, you have to address to the court, not to the other side. If you want to argue with the other counsel, go and sit down in the bar room and do whatever you like. But not here.
That you first demonstrate that why those 2,000 why the return, there's no return.
No, let us visualize. Let us visualize what kind of categories of candidates will be there or appointed will be there. One, you say that diploma holders subjected to selection but found unfit. This is one. Alright. Diploma holders subjected to selection, found fit and appointed. This is the second category. Third category is B.ed candidates who don't have a diploma, found fit, appointed under the notification of NC. The fourth is the B.ed candidates who do also have a diploma and also appointed or not appointed, we don't know. So there can be various categories which can be visualized. Once the Supreme Court has settled the main legal point,
There are what the starting point should be the focus of it. There are whether my learned friends.
please point out that which diploma holder was subjected to selection but found unfit, and yet he is the petitioner.
I don't make a categorical submission in paragraph 17 of my return. It will not be out of place to mention here that 25,000 posts were notified by the government, out of which 22,000 have been. 3,000 are vacant. Means even if we are out, our other friends' clients will not succeed in this getting. Why they want to indulge in this academic exercise?
You make a statement that I am not secret for qualifying marks.
And the state
before that,
Maybe the state government. This is not an issue, not which will be decided in piecemeal method. Me and Mr. Galia, we are not shying away from education. But we do not want not that today one order is passed, then again the state government comes with some facts, that will create complication.
No, it isn't. The ball is not in their court. The ball is now in the court here. We'll categorize, we can visualize all those categories right here on the basis of facts. And then we'll say you do this with this category, you this with this category, you do this, and thereafter go ahead to fill up the
But
vacancy.
there are two reasons.
This is where they are hiding jobs. For 1 year you do not file. Last time it was argued, we didn't raise this submission. It was only for the ad hoc bench. And it was not finally. Now, whereas it was kept with this very much clear intention on 30th April to be decided because we were not available on the next 2 days. That I moved an application that I'm not available. Now, as today they make a submission not on legal points, they make a submission that let there be my submission is very limited. But you can still continue on sir. There may be 10,000 available. If you are intended, but do you have a right to continue in servants? It's not a public interest. Oh, I'm not about public interest. I'm talking about a legal aspect number 1. You have the legal aspect number 2 is that despite I have secured the minimum qualifying marks, I have not been given appointment because my
Who is for the recruiting agency? You are for the recruiting agency. That is what? Which is the recruiting agency? And do you file a reply?
The qualification and accepted by the department was what is advertised on. As per their direction, they are going to and all the advertisement examination.
Alright, and the interveners are all which category of
We are not
appointees?
We are not
Your appointees?
We are the person.
B.ed appointees?
Yes.
All interveners?
Yes. We are the B.ed.
All.
As you also recall, they went to the Supreme Court and Devesh Sharma moved that.
We'll ask for your what options are available to you. And then see on the basis of law whether to accept your option or not to accept your option. Give you a hearing.
There are two different. In one of the
Question is whether it should be here today or not.
in my opinion, arguments are already over.
Because it's already kind of a part.
We are
I cannot technically say it's parted because it's a different bench is different.
my submission is that it would be appropriate if the state government is given a short time to file it. So that they also spend out as to how many vacancies are advertised, how many persons have been appointed.
Why should we point to all that?
That will be required, man. That is
Dead or made?
that will be part of it.
We will say we can visualize 3 or 4 categories.
That is absolutely.
And then we have to say who is going to be out and who's going to be in
Why I say
in those 4 categories and then leave it to the state to fill up.
the petitioners who are here. Out of there are 2 petitions. In this petition, there are 2 petitions. Both those petitioners have been up. So as far as one petition is concerned, they have no locus to say anything in the matter because they have already been up. The another matter is that my friend says we are not very sure as to how many persons are left.
They are diploma holders.
Yes, they are not. None of them is appointed second. Both the petitions, both the petitions, they are the diploma.
They have been appointed.
In one case, they have been appointed, both the petitions.
Hmm.
Please have the appointment order and let them say that no, they have not.
You are talking about which case?
This is a responsible. This is not 13767. In this there are 2 petitioners, A.C. Nandan Sahu, and both of them have been appointed. These are their appointments.
The first case.
This is the first.
There are 2 petitioners.
2 petitioners, and these are their
S.D. Nandan Sahu
and the other one is Rohit Chaudhary.
who is representing them?
They are not. Yeah.
They have been appointed. They were appointed.
petitioners who are appointed.
Then what is your grievance?
The second petition, none of them have been appointed.
No, we are talking about the first one.
The first petition was filed prior to the declaration of the results and the advertisement of the petition was issued.
Then it is infructuous.
Even if it is get infectious malus, it will not be health infectious for the notification in the release software. Because it is only in respect to one of the part that I should be appointed. But the notification, the rules is still under challenge. That challenge goes with the second of the petition when none of them have been appointed despite securing the minimum qualifying marks. So, to the second petition also, Maharaj, I am still unemployed. I am presenting second petition.
Now we come to the second petition.
Now, how is the second petitioner?
Because
His cause is still alive.
for the reason that the vacancies have been occupied by B.ed candidates and we have not been given appointment despite securing the minimum qualifying marks.
You say both have been appointed.
Maharaj, there are two petitions. In one petition,
We're talking about the first case.
first case both are appointed.
Both are appointed.
Yes.
So then, would you like to pursue that petition?
And he may pursue that.
Why? Why were you like? What interim order?
Appointment are subject to outcome of the rate. So this petition could survive alone because all recruitments are subject to outcome. And even if these two persons are appointed, the recruitment exercise based upon B.ed eligibility, that cannot be declared infructuous. The second was checked with this, there none of them have been appointed.
Did you mention in that WP that you were appointed?
That
They have not disclosed it even
time
today.
when the rate petition was filed.
When were you appointed?
Well, these are 4/4/2023.
Yes.
Both these orders are 4/4/2023.
I can see when the
They never disclosed it. We have been saying it.
petition was filed.
No, thereafter. We have been saying it on every day. And you say, no, we have not been appointed.
First day itself, I've said that two persons have been appointed.
They should have said
Rest are
that.
not appointed.
They should have said that.
When did you file this petition? 22/6. 22/6 it was filed.
Was filed once.
All right, filed. When was the result declared?
8/8/2022. That was for eligibility purpose and then appointments were issued free. Prior therefore, the losses made the recruitment exercise subject to the outcome of the rectification of the division one judgment. Thereafter, they moved an IA before the Honorable Supreme Court. That IA was decided, no relief was granted. Then they moved IA before this Honorable Court. Never revealed this prior date. We were there before the Honorable Court. I pointed out this prior date. They have shown them. Then second petition is already there where the persons are not being appointed. They have secured minimum qualifying marks. Are vacancies being occupied by these period candidates? We are not being occupied.
Minimum qualifying marks does not give you entitlement to straight away appointment.
Yes, ma'am.
It is based on merit rank.
They said
It
we
is
are
not.
ineligible. It is not. They said that we are ineligible. Look at them. Okay. And I can only be eligible if I fail to secure minimum qualifying marks.
Yes, so there's another question which arises is, when this entire exercise will be considered again, all 3, 4, 5 categories, and then the entire exercise is considered, there may be candidates who are diploma holder who may have been secured more marks than them. These petitioners in Kesari. So then if that is so, then they'll have to be out.
We are candidates.
No.
Even we can be out. The Rashtra is saying that even we can be out.
Here candidates have occupied the posts which were exclusively meant for diploma. Now once the B.ed candidates are out, in case they are out, then the entire exercise of
Reshuffling is
the select list will have to be made again based on the exam.
Yes.
Was it an exam or what?
It was an eligibility examination.
For the next draft, it will never impact even there was reservation applied. There should be explaining
So
everything.
lot many things will have to be reworked.
I don't know for that, the state will have to give out a reply. The state will have to come out with the figure. For as to 35,000 vacancies were there, why only 22 were appointed? 3,000 candidates were not found eligible. These candidates were not able to be qualified in the examination. We do not know that. Now we are carrying out this whole exercise at the instance of these candidates, out of which 2 have already been appointed, and remaining we do not know whether they will qualify in the eligibility examination. We do not know that.
No, why would I come before the court? I told the simple, you know, if I am ineligible, I would come before the court.
That doesn't
Argue this one.
And then Manoj said that clearly qualifying in the examination to not secure the appointment, that their merit position has to be seen. So the state has to give a reply to that. What would be the position in respect of which candidate?
Scorecard is there. If you go out, I will come to the cutout. So you just answer that how you are there to pretend on service.
First, not right here. First, your local sales. Not right.
So that same issue was raised.
So I think lot many things will have to be reworked.
एक सेकंड में सर ये पिटीशन देख लेना
नहीं ठीक है
सुप्रीम कोर्ट में लगा
तो आप बताइए पर
इसको जरा स्टेट पर
कब करेंगे आप कब करेंगे No, not movies. You're waiting for 1 year without filing any reply. Sit down with your OIC and make your reply this week. We'll place it next week. Otherwise, everything will be washed out from the memory. Week commencing 20th will.
What's my idea option about?
Which idea? We'll hear you. You have a right to only audience, nothing else. You have no right to any relief.
To be allowed yes, no.
No, please don't complicate this. We'll hear you, that's all. That's all. But it's very clear that state unfortunately has not yet responded to the petition despite the same being pending more than 1 year. Next. The state council present in the court is directed to file a reply positively within 10 days. So that the controversy which has foundationally been settled by the apex court by the judgment of Devesh Sharma is resolved in these petitions, which are all filed by B.ed appointees as well as diploma holders. So besides 7, all the remaining 3 are filed by B.ed appointees.
They all are trying to clear up.
The first one is by the diploma holder.
But petitioners are not clear. Petitioners are here.
Diploma. All appointed by diploma. All petitions. Next, the list in the week commencing 20th November. Huh? You can appear virtually. Virtually you can appear. Why do you travel all the way?
Why with this technical spirit? It's very
Use it.
also.
Use it. What is the technology for if you don't use it?
Plus, one person appearing on the physical side, another appearing on others through PC.
We allow hybrid hearing. Why not? No, we don't know because we give you a date. On that date, maybe we have already fixed about 1 or 2 already cases which will take time. So let the computer decide. Computer, searches for vacant slots and then decides in those 5 days, 5 working days. So it can be between 20th and 24th. No, not 20.
23rd?
Let the computer decide. You come to know from your colleague here. So Thakur will tell you what date. They fix date.
Everything would be against those actually brought by the person and that is why I based upon that
That's why it's a short date is given.
So that is why I was requesting that
There cannot be more. It cannot be a shorter date. We will give you a short date.
The Russian will be kind enough for us, same kind to that extent and will provide me any date. How you not price any date?
We will come to know about the date.
So that would be the nature that
In advance, you will come to know the date. At least 1 week in advance.
that would be a tentative date, that will not ensure the skill of the case, but that is what my
No, it won't be admitted today. This would be issued prior to the Diwali vacation of that week, I think.
Yes.
It will be issued on 9th of November, it will be issued. That 20th week commencing 20th list.
Then my anxiety for this would be right? Whatever date we show whether the matter would be listed on that day, that is what my anxiety is. If it is listed now, that's okay, but if it is tentative in the nature that it may then be postponed by the registry itself, that would be difficult for
That's normally doesn't happen.
That is why I was
When we give a fixed date or a fixed week, it is always listed in there. Always. Next, it is made clear that the State Council should ensure filing on a reply, failing which coercive steps would be taken against the state functionary.
It may also be like if it is there would be finally arranged. So otherwise, or again they would seek some atonement for any other
It
reason.
is the parties are at consensus that the matter would be heard finally in the next stage.
Yes, you're right.
2188 1800. Oh, and तो लगे हैं आज which are
On the series start, what will place to be taken again?
state functionary, state functionary. You want that to be also added? I are continuing.